Good afternoon, everybody. Welcome to yet another session on wills and nominations, this time by Mr. Bapoo Malcolm. He's been practicing in the Bombay High Court, and our conversation on wills happened. He actually practices all kinds of disciplines of law, which includes civil, criminal, cooperative societies, family, documentation, patents, trademarks. He's into arbitration. I'm not going to take up more time because he's promised that you can actually get tips on how to do a will, so I'm going to leave the session to him.
There's an old advocate, I think he was a solicitor, very old man, who always used to tell everybody, no man should go to bed without making his will. He died intestate. It's a fact. He forgot to make his. We always put it aside. In fact, some years back, my doctor asked me to make a will, and when I came home, my wife Livia said, let's do the other work first. Doctor's okay. A week later, he was dead. So you realize how important it is to make a will. I think anybody who turns 18, even if he has a few marbles in his pocket, should start making a will. You can change it at any time you want, but it is necessary that at all times you leave some documentation behind which creates less problems for those who follow you. The day Divya and I got married, that was about nearly 10 years ago, she'll remember the first thing when we got home, I wrote down a new will. From the marriage hall, when we came home, I wrote down the new will. Because that is how important wills are. Now, people normally say, "Usme kya bari baat hai, we make a will." But the permutations and combinations that are possible in making a will are immense to the extent that there is no end to what they can be. Let me ask you a question. Who has got 1 crore of rupees to give away? Out of this hand, you got 1 crore of rupees. I'm lucky I married you. Who's got 50 lakhs of rupees to give away?
When you say give away, you mean?
As a legacy.
Ah, right.
I'm sure I'm not getting the right answers because all of you would not be here unless you wanted to give something away. Now here, it's one thing. This guy standing in front of you is a lawyer. Let's not tell him everything. It's normal. It's normal. And one of my clients here, I'm sure some clients of mine will be here. I always appreciate those who do tell me the truth. And invariably, 9 out of 10 don't. So, when I say we are going to write a will, the first thing that we have to realize is we have to be very clear in our heads as to exactly what we want to do. It's interesting. Somebody comes and says, I love my daughter, but I don't love my son-in-law. Now what do I do? My son is a rascal. Daughter is very good. Her husband, I don't know why she picked the fellow up. Now also, this is only the beginning of the problem. This is only the beginning of the problem. When people start to write a will, they realize the complication. They realize that the road ahead is filled with roadblocks. It's filled with potholes. And I won't mention them, but there are people in this room for whom we've been trying to get a will going for the last maybe 4 or 5 years. We've still not come to a conclusion. It happens. So when you start, is there anybody over here who would like to get up very honestly and say, let's form my will here today? May I? Two of more than just one or two. Yes, Mr. May I? Have you written a will?
I am Arun and I want to prepare my will. Okay, I have made 2 wills. I've got the templates ready with me. I want you to check it out and let us know. This will be for all the people.
1 minute. 2 wills.
Yeah.
You can't have 2 wills.
There are 2 templates. I'm not talking about 2 versions of will.
In 2 different languages?
Yeah. No, 2 English languages.
No, here again, it's an important, don't laugh, it's an important thing. Suppose somebody somewhere in the northeast and he writes in some language which no court can understand, I would definitely tell them at that moment that for heaven's sake, get your will translated into English and sign it.
Yeah.
Because interpretation of a will is extremely difficult. It's extremely difficult.
I've got the will formats ready with me.
Is my name on it?
My name is not.
In the residue you can mention everything goes to Bapoo Malcolm.
It's a blank will. So I will request you to just check it out and let me know. I'll be finalizing it right now.
Would you like to, how many pages is it?
Just 1 page.
Would you like to read it in front of everybody?
Yeah.
Why don't you read it? Why don't you read it?
That is, you read it.
No, please go ahead.
See, I've gone through the net and checked
What is
out.
the first paragraph? If we can avoid that first paragraph, if it says you are of sound mind and body, there is no coercion, is it handwritten?
Yeah. No, it's typed.
Fair enough.
I am Arun, aged years, son of Sri so-and-so, Hindu, Indian inhabitant of residing at Bland, do hereby declare this to be my last will and testament which I make this 5th day of March 2013. To my knowledge, I have not any will before this date, but if any other wills or codicils are made by me heretofore, I hereby revoke each and all of them by this my last will in my sound and disposing mind.
Fair enough.
Perfect.
Now, this first paragraph, it seems okay. I mean, you can always add to it. One thing, please don't take it ill. One thing, when you write a will, like in all other legal matters, please make sure that the language is perfect. If I were to write a will in Hindi or Marathi, it would be a disaster. But I would get somebody to correct it, because a comma here, a plural there, would make a lot of difference. And remember that a will, what is a will? It is you talking from the grave. The unfortunate thing is you talk, but we can't ask you questions because you are not there. So finally, it has to be interpreted by the court of law, and it may quite possibly be that that is not what you intended, and it was a problem with the language. So please make sure that the language is perfect, especially in things, normally we've come to a stage when we've started missing out the S's on the plurals. I think it's become a fashion not to write an S in the plurals. We leave out the EDs for past tense. I forget the word, but there was a word that I had read once. It made a totally different meaning because an ED was added. It started with a V or a W, but the ED it sounded wrong, but then you had to interpret it with the first letter of the alphabet and say, well, this is not past tense and this is present tense. A word can change. In fact, Mr. Chidambaram is well known for having argued in the Supreme Court for 2 days on what a comma meant. Of course, at 5 lakhs of rupees a day, I would also do it. But, but it's a fact. What does a comma mean? What does a comma mean? So here, please make sure that the language is absolutely perfect. Don't take a risk with that.
Language means legal.
No. Grammatically correct. Spellings and grammatically correct.
So there are legal wills.
A will does not. Legalese is what we use because we make a lot of money by using fancy words. You don't have to make anything in law which is fancy. You can do it in just plain simple language. There's nothing that says that you must use legalese. In fact, there are movements which say don't use legalese.
It can be simple, but it can be interpreted
Sir,
simple.
Yes.
I've requested everybody, please use the mic because people can't hear what you're saying.
I'm sorry. They're in the other room. They're in the other room.
Do you want to say something? Do you want to?
No, what he said was, should it be in legalese, in legal language? Frankly speaking, I feel that especially a will should be in simple language. In fact, everything in law should be in simple language with everything that fancy words are used. But it's like doctors using fancy language and fancy words, and we don't understand what they are. So it should be written in a language that people can understand very easily. Otherwise, I have seen briefs, I have written briefs which have bad English because I can't understand. How can you expect somebody else to do it? Please continue with your second paragraph, sir.
My family consists of my wife, Srimati Blank, aged about years. I have 2 children, namely daughter.
Now 2 children's. Children is a plural.
Right.
I mean, I don't expect you to be perfect at English because it obviously is not your mother tongue. But this is one mistake. It may not mean much in this context, but somewhere else it could.
So I have to write, I have 2 children.
Full stop.
Full stop. Namely, Pooja and Rasesh, aged years so and so. Now the next one. I am possessed of considerable movable and immovable properties, more particularly described in the duly signed schedule attested here 2. I bequeath and devise the movable and immovable properties to as per the persons mentioned, names mentioned against the same.
Let us stop there. How many people clearly understood what he's trying to say? Hands up, who clearly understood what he's trying to say? 1 or 2, 4 or 5. Now, it could be put simply. It is like a balance sheet. It could be like a balance sheet. When somebody comes to me, unfortunately it takes quite a few days to make a will. It's not that easy to ask a number of questions, get a number of replies. Sometimes they say, hey, itna kaam hai, rane do, jo hoega to. People just walk away because it's like a balance sheet. You have a number of assets, movable, immovable, whatever it is. Have you, by the way, mentioned any assets that I may acquire in the future?
Yeah.
You have. Because you could do it. You might lose something, you might gain something. Make a list of your assets and specify. This mic goes to my son so-and-so. This computer goes to my daughter so-and-so. This lectern goes to my cousin so-and-so. If possible, with a photograph. If possible. You have 2 Chinese vases. Both of them are blue. Both of them are from the Ming dynasty. One vase goes to Auntie A, another goes to Auntie B. Auntie A and Auntie B have never been friends since they were 3 years old. They'll fight over those vases. Even though one vase might be very expensive and one might not be so expensive, still they'll fight over it. The mortal might want the one that is not expensive. It could happen. So here again a photograph would help. Or alternatively you could say the size. If you don't want to put a photograph. Or maybe something that is very specific. You could label it. But then again labels can be removed. So here a photograph would be necessary. If you had a Rolls-Royce car, my Rolls-Royce car goes to my girlfriend so-and-so. But you might have 2 Rolls-Royces and 3 girlfriends. That could be a problem. So you specify that this is what I want to give. Don't leave it very blank. Of course, a simple will should be in 1 page. I so-and-so, 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 so-and-so have all these properties, so-and-so, so-and-so, movable and immovable. I don't have any debts. I leave them to so-and-so, totally, fully, residue, etc., etc., etc. I mean, sound mind, full stop. 1 person gets everything, nobody there. Will you continue with that then? Let us continue with that.
If any of my properties, movable or immovable, are not included in this will or are acquired by me year after, such properties or my share therein shall be treated as residual property and I bequest and divide the same to my wife only, absolutely and unconditionally. I do hereby appoint Mr. Residing Act to be the sole executor of this my will.
Hold on, please hold on. Since you're bringing it up, what happens if your wife predeceases you by a day or follows you a day later? Has she made a will?
Yeah.
She made a will. So then in that case, in fact just this morning we were discussing this matter. These are interesting things that come up. You and your wife travel together. Who dies first according to law?
Yes.
I'm not being crude, but I'm just giving you an example. You're traveling in a car. It's an accident. You get out of the car, try to get some help, maybe crawl along for 200, 300 meters, die there. The wife, do you know when she's dead? You don't. What does the law do then? No, the law is very simple on that. They've come up with what they call legal fictions. The law finds way out of all these things. They say that the eldest person died first. When they cannot make up their minds, they say the eldest person died first. See, I'll tell you one thing about legacy. And this is a British system which we have very fortunately inherited. They do not like any property to lie fallow. As soon as the will is dissipated, the better it is. The people always say court mein itna time lagta hai. The courts, especially for testamentary matters, like to finish it off as soon as possible. It's a British system because in Britain, the land goes to the eldest son. And if there is litigation, the land lies fallow. So it must be put to good use. It's like a court receiver wanting to put property to use so that there is income. So the law is designed in such a way that they come to a conclusion as soon as possible. Unfortunately, in a democracy, there is no law which says that you can't challenge something or the other. People can always do it, no matter how good your will is. If somebody wants to challenge it, he can. Okay, sir, let's continue.
Yeah. I do hereby appoint Mr. Rasesh, Residing Act, to be the sole executor of my this will. If he is unable to act, I do hereby appoint Mr. Navneet, Residing Act, to be the sole executor of my this will.
Okay. Your legatees, I presume, are your wife and children. You haven't left anything to anybody else. Why have you not made them executors?
Sorry?
Why have you not made them executors?
My wife and my son is Rasesh is my son.
That is your son.
Yeah.
I'm sorry because I did not
And
know.
Navneet is my friend. So
Okay.
just in case if my son is not able to execute, Navneet, the second executor, will execute the will.
Now here, we always recommend that one of the legatees, at least one if not more, must be made an executor. Why?
First one.
But in this case, it is.
It is. Because the name wasn't. He's done the right thing. But the question is why? Somebody might not want to do it. But let us find out why it should be done. Why do you think it should be done? Suppose this gentleman, what's your name, sir?
Arun.
Arun makes me an executor. And he's got a lot of properties. I refuse to execute it. I blackmail his children. Or I might die the next day. What happens then? What I'm trying to tell you is making a will is not that easy.
Can I ask a question?
Yes.
What if, he makes one of the sons an executor and that son has got less property than he's leaving, say, to his daughter? Then won't the executor also be, doesn't matter that he's the son or the daughter, won't they also misbehave and not?
I fully agree, and if something like that happens, the person who will benefit the most will be the lawyer, because they're going to challenge it. I'm not saying that make only the son, he can make both, the son and the daughter. He can make both of them, he can make even his wife the executor. There's no law which says you have to have only 1 or 2 or 3. You can have 100 executors for 50 items. But the idea is that you must make sure that it's executed. Now, if suppose the executor fails to execute for some reason, might be dead. I know one of my clients might be here, we've had this problem, maybe he's in the other room. The executrix was unable for particular health reasons to execute the will. What happens then? We had to go to court and get a court order to appoint somebody else. Now, the lady was one of the beneficiaries, but at that moment she could not execute it anymore. And the other executor, he recused himself. He says, I'm not going to do it. Now what? So it is always better that a person who is going to benefit from the will is also named as an executor, because it is in their interest to make sure that the will is executed. Now I know a lot of people who want to make a will and don't want to tell their children what they are giving them. No, I don't want to make that. Another thing about executors, please, for heaven's sake, get some sort of document from the executor that they are willing to execute. Don't just put down anybody's name without asking them or getting a cursory yes. You can't force anybody to execute your will. And if you want to make it a little bit more palatable for the executor is entitled to expenses. So even a paragraph to that extent would help the executor to do his duty. Normally executors balk when there is a challenge to the will. They don't want to go to court. I mean, by the time you get money out of the estate and pay the advocates, it's the executor who has to do it. Unless somehow or the other you can manage to tell the court that, well, part of it can be liquidated. But it's a hassle. So please get your executors to agree to it, and then make sure the executors are younger than you are, not old. I mean, yes, tell me.
So when we are talking about the executors, for any reasons, let's say we have a joint executors. We appoint the joint that they.
All executors are joint.
But before I die, the executors have already died. Do we have to change the will?
Codicil.
In that
That's
case,
why I have 3 or 4. And please don't keep them from the same family who might go up in the same plane and all of them might die together.
So that order is allowed. That
No, don't laugh. It happens. It happens all the time. It happens all the time. I make my brother, my sister executors, and we all go out in a car and fall over the cliff. What happens? It happens all the time.
So I can put an order that the first one is not available, then the second is not.
No. You can't do that. Executors are executors. You can't
So if
distinguish
I put
between
4
them.
people as executors,
So
and-
your second executor might kill the first.
yeah. So then what happens is that the balance people will be
Yes,
continued.
they would. And if suppose you have appointed 4 executors, 3 of them die in an accident together, or maybe one after the other, you can always prepare a codicil and appoint more executors. See, a will, as long as you are living, can be changed, manipulated, even torn up and thrown away. There is nothing that can stop, because it is your document until you are alive. The moment you die, it becomes frozen. Then you can't do anything to it.
Can I also add the condition there that this executor should take the advice of my lawyer at the time of executions for investments or other reasons, and they should pay a reasonable fees to that lawyer for doing that work?
You are putting a condition.
Not conditions, but maybe a suggestions there in that.
You can put a suggestion. In law, suggestions mean nothing. In law, suggestions mean nothing. I suggest that you talk to him, but you would not necessarily take his advice. But why not make the lawyer himself one of the executors? You've been made executors. Executrix. Yes. I'll repeat your question.
Is an executor supposed to know what is there in the will?
Is an executor supposed to know what is there in the will? No. Not necessarily. No. Nobody is supposed to know what is there in the will, including the witnesses. Because the executor does not even know when you are executing the will. If I make a will and make, say, 1, 2, 3, 4 people my executors, I don't have to call them when I'm signing the will. But I will call these 2, at least 2. They will attest that it is my signature. I'm in the right frame of mind when I'm doing it, that I know that this is my will, there is no hanky-panky. Witnesses. And they don't have to read it. Nobody has to read the will. Yes, witnesses cannot be executors, and the witnesses should be people who cannot get a pie out of the will. They have to be totally independent of the will. They cannot accept anything.
Excuse me, sir. Yes.
Yes, my wife just reminded me. Spouses of the executors also, they are on the same footing as the executors. So, leave them out too. Best thing for witnesses is to get your doctor and your lawyer, somebody separately, so that they can vouch for your health and your mental capacity.
Sir, it appears to me that the best thing to do would be to have the people who are legatees, only they should be executors.
You may.
No, because in which case, so let's say I am willing to my wife and 2 children in whatever measure, anybody else outside need not be an executor.
You may. Now take my will. Not that I'm leaving anything to my wife, I don't have anything to leave. But still I made a will. I made her an executrix. Suppose we are traveling in the same car. I die, she's incapable. What happens? Wouldn't a third executor, a person away from me, be able to execute my will? See, I'm telling you, in wills, the number of permutations and combinations are so great that it's almost impossible to say I have drafted a perfect will. It's impossible. You show me a will, I'll show you something or the other that is either missing, additional, subtraction, whatever it is. It's almost impossible. Now when you say how to write a will, I think we are exaggerating a little bit.
A second part of the question.
Yes.
If I am making my children and my wife as executors, do I still need in writing their agreement that they agree to be executors?
if it's your wife and she's one of the legatees,
Only the legatees if I do.
I'm sorry to use the word, but it would be stupid on our part not to execute it.
Yeah, so in which
So
case...
he's going to do it.
So I'm assuming that if I am making the interested parties like this as the executors, I don't necessarily need, or is it still better to keep that?
No, it's not. I mean, if you know that they are going to execute it, that they are going to be the beneficiaries, it's not necessary.
Within the bounds of knowledge.
Nobody, to tell you the truth, nobody asks for a letter from an executor. I can guarantee you that. Nobody asks some of them write names of executors without the executor even knowing that a will is being prepared. हाँ, उसका नाम लिख दो ना, अपना दोस्त है, वो करेगा काम. So at that moment a person, he has a right to refuse. And even if he says, yes, I'm going to do it, he gives it to him writing, he might still refuse for some reason or the other. He might say, I'm too old, I'm sorry, I can't do it, I have other complications in mind. So here again, you have to be careful. Now please, okay, there's a 1 minute, there's somebody else.
When I start writing the will, in the initial beginning, do I have to mention the names of all my heirs?
Okay, we come. This is interesting. I was hoping that somebody would ask me this question. Please sit down. Please sit down. Please sit down. Suppose you have 4 sons.
Yeah.
One of them is totally useless, drunkard, addicted, etc., etc. You say to yourself, damn it, I wish I didn't have this guy. But you have him. Now what do? You want to cut him out? If you want to cut him out completely, you can. It's your estate, you can. But leave him 1 rupee so that he cannot challenge it saying that my father had forgotten me. I'll tell you, my grandmother and grandfather couldn't get on together, so my grandfather left her 11 rupees. He left her 11 rupees. The servant he gave 101. He left her 11 just to show that the will, I have purposely applied my mind and given her only 11 rupees.
Secondly, if I have assets and I'm leaving it all to one person or 2 persons, instead of listing it out, can I simply say all that I own and possess?
Yes, but then 2 persons would be 50-50.
Divide 50-50.
Make sure that it is divisible. Make sure it is divisible.
Where the problem comes in case of jewelry. Now in jewelry, you can't break the jewelry and give it half.
Exactly as I said, make sure it's divisible.
So what do we do with the jewelry? If you want to divide it half.
You can put it into the clause this way. Now suppose that this is your son and your daughter, and you say that I'm leaving everything to them, and this is a piece of expensive jewelry. If you broke it up, it might be worth 1 crore of rupees, but if you broke it up, it would not be worth 5 lakhs each. Maybe the karigari in that is expensive. You can put it in this way. It will go to either my son or my daughter, and they can, each one of them can decide on the price, and whoever thinks that they can pay more will pay the other person and take it.
Okay. Can the executor...
it will be difficult for the executor, it will go into litigation.
Okay.
See, how can the executor break it up?
No.
He doesn't have a right. He'll say, this is for the 2 of you. Now you settle what you want to do. The executor has no right to break it up. He cannot, he's not a judge.
Okay. Last question. The 2 witnesses who are required, it is said that they should be independent, but can they be one couple, husband, wife?
Preferably not.
No.
Preferably not. Keep them independent. I'll tell you why. Very often, wills are challenged on the basis of signatures. That is why we always prefer a handwritten, a holographic will. So it's typed and signed very often. And normally when people write a will, their handwriting shakes. People start challenging it. So if you have 2 young independent witnesses who can then attest that, yes, I saw Mr. So-and-so sign on this particular will at such and such a day, nobody can challenge the signature. The idea of a witness is only that you have signed it when you are in full control of your faculties and that it is your signature, that it is not a forged document.
Thank you.
You won't believe the number of forged documents that are moving around these days. Huh? Hundreds of them.
I wanted to ask one question. Is an executor necessary in a will? Is it mandatory?
Otherwise, who will act on the will?
The legatees.
But then there are the executors. You make them the executors. Say that they are the executors. Otherwise, if there is no specific mention, I am leaving everything to my wife and children, they'll have to go for a probate. The court will appoint somebody. An executor is nothing more than a person who works the will. You could have your solicitor do it for you. He can open up the will in front of all the legatees and read what it is. But after, somebody has to do the nuts and bolts. Is Mr. Contractor here in the other room? No. He's a client of mine with exactly this problem occurred. And we had to have an executor, otherwise we could not move further, and we were not keen on having the court appoint somebody. So an executor is necessary. I know it's difficult to get executors.
Executors. If there are two executors, one is my legal heir and the one is my friend. Now they both have to execute, or they can either one can execute.
The executors can fight with each other. I mean, you can't deny that possibility. They could fight with each other.
If one is unable to act, then the second.
Yes, if one is unable to act, the second one goes to the court and says, Mr. So-and-so does not act on it, please remove him.
And I'll execute.
And I'll execute it, or otherwise, better still start executing with information to the other guy that I'm executing this will. If he sits tight on it, go ahead.
So they don't have to go together to execute the will. No?
See, it's like this, interpreting the will. Now here, the language. Your son says, this gold jewelry comes to me. Your executor likes your daughter better than your son. Says, no, it should go to her. See, that's where the problems arise. As long as the executors are of the same mind, there should be no problem at all.
Either one can execute.
If the other one doesn't execute, the other one should, in fact, he should go ahead, not even wait.
Right.
Start executing as soon as possible. Keep the other fellow informed that I am doing this.
But
if he doesn't like it, he will interfere.
He has to inform the other person that
Yes, keep him informed that I am doing it. You're sitting tight over there and not doing it. That is why I am doing it. If he wants to interfere, he will interfere. If he doesn't interfere, well and good.
Sir, the second executor does not know that his name is there in the will. Only the first executor knows that his name is there.
You should let the executor know. That's what I meant. I mean, people write executors' names without telling them.
When a will, father and mother have expired.
Father and mother have expired. They made a will.
Will, yeah.
Okay.
Executors are there.
There are executors,
There
okay.
are two sons.
Two sons.
Assuming that the one son is going to challenge the will,
Yes.
what is the formality to be handed over to the will to the children, to the sons?
The two executors are of one mind.
Yeah, that is, they are of one mind.
The one son, son A, I say S1,
Correct.
is not happy with the will. He wants to challenge it.
Right.
Unfortunately, sir, in a democracy like ours, there is no law which prevents you from going to court. If he wants to challenge it, he is going to challenge it. In fact, I thought that I'd talk about it later. It's one of our legal systems whereby you cannot stop a person from going to the court of law. Unfortunately, when we say the courts are clogged with cases, I can guarantee you 75% of the cases are bogus, frivolous. They are filed by crooks. What I'm trying to tell him is this. So there is no way in which you can stop the son from going to court.
But what is the method of getting the things done? It should be in presence of...
Yes, get the probate, start probate proceedings.
Okay.
Go to the court and ask for a probate. The court will give a public notice, let the legatees know that this is the thing, let him come forward and challenge it. But the executor should go ahead. They should not wait for the son to file cases, or if he doesn't like it, it is their job to execute the will. So they must go ahead with it.
So probate is the first step, and then...
Yes, go ahead with it. If there are only two guys and they are happy with and they say let's divide it,
Correct.
there may not be even need for a probate.
And what is the importance of registering a will? Or is it okay?
It's a very grey area in law. The idea of making a will very inexpensive is that the government wants people to make wills. That is why you can make a will on a piece of paper. Any piece of paper, lined, unlined, anything. You can even make a will on a serviette. Okay. It's true, you can. There's nothing that says that you must make it on such and such a paper. If you go somewhere, somebody says stamp paper pe karo 25,000 do, 50,000 do, it's bogus. You can make it on a piece of paper. You make the will on a piece of paper, go ahead with it. Now what's your problem?
So if a will is not registered...
Registration, now here as I said, it's a bit of a grey area. I make a will and register it. Suppose I want to change it.
Okay.
There is no law, at least it's not been crystallized as yet, as to whether my codicil or my second will must be registered. I'll tell you why. I make a will, I register it. At the last moment when I'm dying, I all of a sudden realize that so-and-so is a useless person, I want to cut him or her out of the will, I make another will. I may not be able to go to the registrar's office at that time. It might be a Sunday, it might be a holiday. Which becomes my last will, the one that is registered or the one that is not registered? It's a grey area. If you are registering it, please make sure that you keep on registering it.
Okay.
If you do not register it, it's quite okay. The will is valid. The only advantage of registering a will is somebody may not destroy it. You might lose it. It might go somewhere. You might not find it. So if you register it, at least you know that there is something in one government vault which you can get out of. But I personally, that's my opinion, if you register it once, please register it again. So that there is no lacuna, there is no grey area.
Correct.
So if you do it, please keep on doing it all the time.
Thank you.
Sir, my father-in-law has made the will, but he has not registered. So shares, we can't transfer on the mother-in-law's name. Now they are saying you have to register this will, and my brother-in-law is not ready for that. So what is the...
Who says you must register a will? There is no law which says you must register a will.
Probate the will.
Yeah, probate yes. Probate yes. See, now let's look at it this way from the... See, we always have to look at it from the other side too. A company. You are asking them to transfer shares. Once they transfer them, they've had it. So they will do their damnedest not to do it. Give me this paper, give me that paper. People like to play safe. And the best thing to do is when you buy the shares, keep a record of that, keep it registered. Now here again, how to solve this problem? I buy shares very often, and more often than not, I don't tell my wife that I got the share, I don't put her name on it for some reason or the other. Only I have the share. What's wrong in putting the second name? Tell me what is wrong. Same thing with bank accounts. Keep one bank account, one name. Nominee. Problems. Why can't you have a joint account?
Sir, one more thing. If one person is having two sons and he has not made the will, and that sons are having
50-50. 50-50.
Their kids also?
No, the sons.
Only sons.
Sons. But if the son, the father predeceases the son, that means the father dies today, the son dies tomorrow, then that son share will be divided between maybe his dozen children.
Okay.
But otherwise,
It's 50-50.
simple. There is no hassle about it. So there are some religious laws which don't allow it between son and daughter. So the thing is, whenever we make a will, we also refer to the religious laws. Up till 92, even Parsis, it was one share for a son and half a share for a daughter. Yeah, up till 92. Then we decided that we are splintering it up too much, so made it very simple. Everybody gets it.
Yeah, good evening, sir.
Yes, sir.
Just a couple of questions. One is that, like you said, that the will should not necessarily be in own handwriting of the person. The will should not be written in the own handwriting of the person, if it's quite old.
No, it should be. I would like it to be in his handwriting.
No, I agree, sir. But what I'm saying is, a person is about, say, 85. He doesn't have a steady handwriting, and it's not possible to write in his own handwriting.
Yes.
So in that case, can
somebody else writes it for him because they don't have a typewriter?
No, can you be drafted like somebody else drafted? Yeah, correct. What you're saying? Yeah, can that be done?
It can be done. I mean, there's no law which says that you can't. But in a case like this,
yes,
in a case, is the person educated or not?
Absolutely,
the problem.
Educated.
Is he literate or not? Can he read what is written? You get it? And if he cannot read what is written, what he should do is, if he's in good faculty, is to call some third person, a total outsider, ask him to read what has been drafted and make sure that that is exactly what he wants. And get that person to sign here saying that I have read this to Mr. So-and-so and he understood what is written.
I was coming to that, sir. That the witnesses that you said who will be witnessing the will, either preferably should be a doctor who will say certified.
I mean, they say doctor and lawyer, but it can be anybody younger than you.
Oh, fine. In this case, I would like to have a doctor present there, and he will read out this contents of the will to the person making it.
If the person wants it to be read out, there is no law which says it must be read out.
No, I know, but
I'll come to just 1 minute.
Yeah.
The witness will only say, this is your will, are you happy with it, have you read it? He says, yes, I'm okay. That's more than enough.
Okay.
That's more than it. The idea is that the man is not under coercion, no one is forcing him to do it, he's in his right mind, he's in good health, and he knows what he is doing. That is all. And that the signature is his. That is all that the witnesses have to do.
One more point that I want to clarify. After the will is prepared, should it be sealed and kept somewhere, or it should be kept where?
I'll tell you.
Yeah.
It should be kept in a proper place. It should not be kept just lying around where it can be destroyed or eaten up or moth-eaten or maybe in the floods. 26th of July, everybody's wills got washed away in the floods. Millions of wills got washed away in the floods. So keep it in a place where it is safe. A lot of people leave it at solicitors' offices. Here again, rather than the solicitor's office, if you want to keep it in a safe place, I would suggest keep it at the registrar's office. But then, please tell your legatees and your executors that you have done it. Otherwise, you might die, they won't know where the will is, so please tell somebody that you have registered this will and kept it in such and such a place. They give you a small receipt for that. And that if I die, they'll take your death certificate and release it. And on that envelope, you have to seal the envelope. All you got to write is last will and testament of Mr. X, Y and Z, dated so and so, deposited with the sub-register of assurances, Mumbai. That is all that you have to write. You don't mention anything else, not what's in the will or anything. It is just for safekeeping so that you can access it, your executors can access it when you die. Otherwise you keep it at home. I, for one, if I had to do it, That's another thing. We made some points which we'll talk about later on. Suppose I have 3 legatees, 3 people whom I want to leave things to. I would make all 3 of them my executors. I would do that. And maybe a 4th or a 5th person just in case of a problem. And I would leave 1 copy of the will with each person properly signed. So they know what it is. But there are a lot of people who don't want their children to know what they are leaving them. That's where the problems arise. Because they are worried that if I tell my son or my daughter that I am leaving them only this much and the other one that much, he won't look after me, she will look after me, but then she's got that boyfriend over there, he will not tell her how to do this. See, people think of all these things and that they are in effect creating problems, they are not solving them.
Suppose the will is already made and in that the parents are leaving properties and assets to one particular person. Can the other family members object to it?
You can object to it, but you are not going to get away with it. You won't get anything. If I want to leave, say, 100 crores of rupees to my son and nothing to all the rest of the family, including my wife, there is nobody on earth that can challenge me. It is my money. I can do damn well what I want with it. Full stop. You can challenge it, but you won't succeed.
And in case some of the properties are, on lease, that is,
Yeah, we'll come to that. We've got one draft of a will where we've talked of leases, we've talked of rented properties. We'll come to that also. Okay. How many people are living in rented properties right now? Not many, fair enough. But we'll come to that also as to what to do with rented properties.
Thank you.
We'll come to that.
If there are 5 or 6 points in a will, and if there is one point where one of the legatees does not agree with, then will the whole will be stalled?
We've got that also. Election. We've got that also. Now suppose I leave something to 2 people, say my son, my daughter. I leave all this to the 2 of you. My son does not like this. Or it might be a liability. He says, I don't want this, I only want this. Sorry. You either take everything or nothing. So it is called election. You can step out. I was almost made, I had personally walked into a trap like that. I elected to walk out. Otherwise I'd have been in serious trouble. You have to say yes or no completely. There's no halfway measure. I'll explain to you why. Things like call money. You got shares, call money. One fellow says, I won't pay, you pay. Why should I pay? So you have to take the good with the bad. You can't say, I'll take the good and not the bad. It's called election. At that moment you have to decide. And just last week we had this problem. Just last week. Somebody gave up or said that they gave up some property for whatever reason, whatever it is. But when we asked them the question that fair enough, on the death of your parents you gave up this stuff, did you accept even 1 rupee, maybe a ring, maybe a glass? Because then that's not election. Election has to be complete. It's one of these areas of law which people don't normally,
What is an election?
Election means I elect to do something or I elect not to do something. If, as I said, if there are 10 things, I cannot say that I will take my 50% share out of these 9, but not out of the 10, because the 10 might be a problem. I have to take the 10th also and live with it, otherwise I have to give up the other 9.
Excuse me. I am an ex-banker, and there was
dangerous.
No, in fact, you learn a lot being a banker.
My father-in-law was a banker.
So there was this very interesting case where the person kept the will in the locker, and the person was the only, locker holder. That is a very dangerous thing to do.
It is.
Because as a banker, you cannot allow anyone to access the will once the person passes away. Even in case of spouses, where, both of them are joint holder for lockers, I would suggest not to keep the
you might
will.
suggest it, but there is nothing you can prevent.
No, it cannot be prevented, but
You
here...
can prevent me from opening the locker.
So here we are
I don't
talking
have to
about...
tell you
Yeah.
that so-and-so is dead and I'm opening the locker today. Somebody might die at 1 o'clock today, at 1:10 I'll open the locker.
No, but the thing is, how about the access to the locker? It was single access.
Single access, you got to go to the court, you go to the court and get an order from the court. There will be a panchnama, they will take whatever is in the locker.
Correct.
And if there is a will, you go back to the court and say, this is the will that we want to execute.
Yes.
That's a different thing. But otherwise
It is not. You cannot
Somebody
prevent
else
what
has a-
anybody is putting into the locker. That is
somebody else has access to the locker, there is nothing in the world that can stop them from doing it.
Sir, I have one simple question that about the executor. Is there any time frame given by or suggested by law as कितने दिन तक ये execute हो जाना चाहिए, or do we take it as
Normally
1 month, 6 months?
limitation is 3 years. Anything more than 3 years is a
years.
dead letter. But
Okay.
then the legatees should make it a point to force the execution. I wish Mr. Contractor was here. All that you are asking, Mr. Contractor, are you in the other room? You're supposed to come. All these problems we have gone through with that gentleman. Non-execution of will for 7, 8, 10 years, I think, 1999, and he came to me about 2 or 3 years ago. Nothing. Dead. They were supposed to form a trust. Nobody's formed a trust. Nobody's collected rents. There's 2 lakhs of rupees lying in some bank account. Nobody knows the bank account number. Nothing. Zero. We had to move the court and do the spade work ourselves.
So basically, as early as possible is what we look for.
While the corpse is hot.
Yes. Thank you so much.
Yeah. My question is, if I have only financial assets and I hold them all jointly, do I still need a will?
Not really. I mean, this is something which I normally explain to my students as a co-ownership and joint ownership. The simplest example that I always give is that of a very expensive painting. A co-ownership of a painting would mean you could tear it apart, which would mean nothing, it would be a waste. A joint ownership goes to the survivor. Simple as that. So keep it joint.
So even property, if everything is...
Keep it joint.
Okay.
Keep it joint so that, I think you'll agree with me on that. Keep it joint.
Okay.
She's a lawyer, she doesn't agree with me on everything. But keep it joint so that there is no hassles.
Okay.
Please.
The next,
Your bank accounts, everything, if you keep them joint, it's a lot less of a hassle. Lot less of a hassle.
And no challenges on that either?
I'm not a tax expert, but if you pay tax on something, and if you're a joint holder, I don't think, and if there is a tax on it, I think it will be very little. It will also 2-3%. I'm asking you. She knows tax laws better. The idea is that if you have maybe $1 million, if we had $1 million in our account in the locker, I died. No, you died. And I get the money. You earned it, I have not earned it. But it's joint. Estate duty. Faye, the expert says, go ahead.
But the government is thinking of...
This year they wanted to bring it in. I don't really know, because in the Rajya Sabha it was passed without discussions. I don't know what they are doing now. We'll come to know within a month or so.
So the other question...
I think Mrs. Dalal would be able to... They haven't done it as yet.
So the other question is that if I do have a will, are there instances where I do not need to get it probated?
Instances where?
It does not need to get probated.
To tell you the truth, if there is no fight, there is no need for a probate. Don't go in for a probate. You have to pay money for a probate, and if there is no fight, distribute it. Just distribute it. if there is no fight.
So just one corollary to what he's asking, as he said, if husband and wife are joint holders in bank accounts and other assets, and there's only one child, so in that case, does making a will, is it really required?
I don't get it, ma'am.
Husband and wife, joint holders in all
Joint
assets,
holders.
and there's only one child who's been nominated in all the assets.
Yes.
Do you really require a will in such cases?
You mean they got own money in the bank and no other assets at all?
No, suppose there's a property, all are in joint names, and the
Yes.
nomination is given to the child. The child is the nominee.
Still, please. This concept of nominee, I am not at all happy with. It has to be very specific. I am not at all. If you Google nominee, you will get 12,543 definitions.
No, so I'm asking in today's...
I'm not at all happy with this nomination thing. I'm not at all happy with that. Make it specific, say it must go to my child. What's wrong? And if your child is underage, please appoint a guardian. Or otherwise the court will appoint a guardian. If your child is underage. But please be very specific in your will. All these things which you leave up in the air. A lot of people leave it up in the air because they want fights after they are dead. I'm not joking. They enjoy it. बाद में होने दो ना कुछ भी होएगा लगा करते रहेगा. So please be very specific in your will that this must go. That's why I said it's like a balance sheet. So and so, so and so, so and so, so and so. With pictures if you want. As specific as possible. I'm not saying that you make a will of 50 pages. My great-grandfather made a will of 50 pages. It was thrown out by the court because nobody could understand what it was. Handwritten. Every time, the joke was that every time we go to his house, he's writing his will. I still have it. I have preserved that will. The one that was thrown out, I have preserved it.
50 pages of it.
50. Handwritten. And that time, pen color.
One question, sir. If the legatee and the first class hires, if the legatees
yes.
and the first class hires are died before the testator and the executors without informing the second class hires obtain the probate and sell the property, after lapse of 15 years when it came into the notice of the second class hires that this has been done, can they go to the court for revocation?
My wife is the right. I've asked her to come for this. I'm not very good on Hindu law. You ask me Parsi law, Mohammedan law, Christian law, yes. On Hindu law, she's the expert, so she'll answer you. Give her the mic, please. That's exactly what...
As far as trust, matters concerning trust are concerned, the limitation, when you say the executors have done something, the executors are really in the position, their office is that of a trustee. Whatever they do, they don't do it for themselves, they do it for the beneficiaries. So if they, of course, if they have done something wrong, if anybody does anything wrong in a capacity as a trustee, then the true beneficiaries of that property, not only in will in general, they can follow that property in whosoever's hands it is, because limitation is just not applicable in matters of trust.
In matters of fraud, and what she means is an executor works as a trustee. He only helps. And if even after 10 years, 15 years you find that there is a fraud, you can follow that fraud and recover your property. There is no such thing that says, see, a fraud is by its definition a concealment. If I am going to defraud you, I am not going to tell you, Mr. So-and-so, I am going to defraud you. I will do it behind your back.
So good evening. I have actually a couple of questions. I'll try and be very brief. What's the difference between nominating somebody and writing it in the will? Normally you have a nominee in most accounts and you nominate a spouse or a child. But in the will you may...
Ms. Dalal, should I go ahead with this? As I said, 12,543 as of this morning. Different definitions of nominees. That is why I say, please don't use that word. be very specific. Because a nominee stands in different positions in different cases. In a bank account, in your shares, in your cooperative societies, everywhere the definition of a nominee is unfortunately different. The biggest problem of nominees is with cooperative societies. How many of you think that a nominee in a cooperative society should get the flat? How many of you think it's correct? I've got a judgment over here. Not now, 25 years old, which distinctly says that a nominee, yes. So don't use that word nominee as far as possible. Please keep away from that word, because it will finally have to be interpreted by the courts, and we don't want matters to go to the court. So try and be specific. This must go to so and so, this must go to so and so.
So the question is that if it is properly defined in the will,
yes,
will the will prevail or the nominee?
No, the will prevail. Full stop. Will prevail.
Okay. Thank you.
Full stop. If it is properly defined, the will prevail.
And so last question is there a way to digitalize, look after your digital content?
You mean as intellectual property?
No, as in I've got I've got things on Google, I've got certain email accounts. Is there something that I can do to that? There was an article this morning also on Google.
It's interesting. Let's think of it. You have something on Google. Is it worth anything?
Possibly.
No, I mean let's be specific. Is it worth anything?
If I'm an IP, yes.
Why you put it on Google then? Why are you letting the world know about it? If it is important, you'd like to keep it a secret. What can be on the air in digital form except maybe patents, copyrights, something that is worth more to you than it being on the air?
Okay.
I mean, it's there. What do you want to do with it? Give it to your son? Then give him your password. That will end the matter. If you've got some copyright on the air, which my wife is doing, I have a password. She's putting a novel on the air. Now obviously it's worth something. Obviously it is worth something. I hope it's worth hell of a lot. That she can leave to me, hopefully, or she can leave to somebody else. So give him your password. It's as good as you leaving it to him. In your will you write, I've got something in the ether, whatever it is, and the password has been left with my sons, he can access it and do what he wants with it. Very legal. You are giving something that you own to somebody who can use it. It's interesting. I think in later years this is going to come up quite a bit. Yes, it's going to come up quite a bit. Why don't you copyright it? That will make it the safest. Copyright it, and then you can give the copyright to whoever you want to. So even if it is stolen, your password is stolen, people cannot use it. Copyright it.
Since you said nomination supersedes the will, will supersedes the nominee. Suppose you appoint a second applicant to your property or any of your documents.
Applicant means?
He is a joint owner.
Joint owner? Yes.
So, if it is a joint owner, and if you don't make a will, does it go directly to him, or will supersedes that?
No. See, you have made somebody a nominee in a bank account. As I said just some time back, you die at 1 o'clock. Your joint holder can clean out your account at 1:05. Anything to stop it? He has access to it. It's either or. He has access to it. It's his. Full stop. How can you stop him?
So will doesn't supersede it?
No. because it's a joint account. As I said, you can't tear these things up. He will go ahead and do it. No, not, he's talking about joint account. Somebody else has an access to that. How can you stop them?
So second holder is always better than the nomination, you mean to say?
A will, in my opinion, will always supersede nominations.
What happens when the karta of a HUF expires? Does he have to bequeath that account also, or what is the procedure?
My wife, she'll tell you how it travels from the karta to the next person.
Under the Hindu Succession Act, anybody can make a will as far as his or her interest, undivided interest in the Hindu joint family is concerned. And so supposing Mr. A, he's the karta of a Hindu undivided family and he has a 20% interest in that family. He can, for his 20% interest, make a will and say that I will, my 20% interest goes entirely to my wife. If he does not make a will, then the Hindu Succession Act comes into picture, where they have given class 1 relatives, class 2 relatives. If a female dies, they have a different itinerary. So that's it.
Mainly it's how you have acquired that. If it is self-acquired, you can do anything that you want with it. Any Muslims here? You people would have quite a number of questions to ask on wills.
Hello?
Yes.
No, I have a son and a daughter.
Yes.
According to...
You have a son and a daughter.
Son and a daughter. After me, my son will get double of what my daughter will
Yes,
get.
that's true.
And I want both my son and the daughter to get equal.
Fortunately, with only 2 children, it's possible. Give her 1/3. And let the rest be divided. You are allowed to give away 1/3 to whoever you want.
That's correct, but I want to give for my property half to my son and half to my daughter to make it equal.
Give it away now. Why wait? Under their law, they can give away 1/3 to anybody that they want, which is a fantastic thing. It's absolutely a fantastic thing. I mean, if Mr. If Mr. So-and-so, hey, Mr. What's his name?
Khan.
Mr. Khan has a girlfriend. He can't give away more than 1/3 of his assets. The best has to go to the family, which is a good thing. It's a fantastic law. I mean, it's really good. Tell me.
I believe Shia Muslims can make a will for the entire property. If you're a Shia Muslim.
Yeah, that's again the thing. Are you Sunni or Shia?
Sunni Muslims, they'll have to take the permission of all their legatees to make a will for more than 1/3 of their property.
If you want to give more than, see, your son will get 66%, your daughter will get 33%, right? If you want to give 50-50, and if your son is willing, no problem. If your son is willing to give away 90% to the daughter, no problem. But your family members, the idea is that family members are looked after. That is the idea.
But what this is nice. You give away 1/3 to your daughter, so the remaining, even if it gets divided 2/3, 1/3, she gets half.
It's just because you have got 2 children. Otherwise, it would be a little bit more complicated. Is your son willing to give her half? He is willing.
Sorry, Irfan, please use the mic.
ICICI Bank writes wills, and I had approached them once some time back, and they said, yes, you can write the will, we'll write it for you, but you have to get a letter from...
Banks would write the will for you?
Yes.
Okay.
They have a company.
Okay, fair enough.
And they said you have to get a letter from your son, he should read the will, that you are giving half and half, that he agrees with it.
If he agrees, there's no problem. If he agrees, there's no problem. Or give it away now. Forget it. Settle the matter.
Sir, I wanted to ask you, if in the will it is mentioned that the share should go to the nominee as mentioned on the document.
But then that doesn't become a nominee, because a legatee. When you mention it in the will that it should go to Mr. So-and-so who is my nominee, he is actually a legatee. He's the beneficiary. He's no longer, doesn't matter who the nominee is. You are giving it to him, you are gifting it to him, so it makes no difference. Don't remove his name from the nomination just because you're making him a legatee. Please don't.
So if it's in the will that...
Yeah, it will go to him. It will go to him. See, normally, at least if I had the money, what I would do is, if I had a number of shares, to prevent all problems, I would decide that the second name on shares A lot would be so-and-so, shares B would be so-and-so shares. I would divide it from the beginning so that there is no problem later on. Automatically it would go to the person that I want it to go to. Finished. But people don't want to, the tendency is to hold on.
If you want X number of accounts, divided in the beneficiaries' names with the principal, then you have far more expenses during your life, no? Because you have to pay a set of expenses for each account you open.
That X figure should be a couple of dozen children.
Even if it is 3 or 4 or whatever.
Have them no, what I'm talking of is shares. I was just talking of
I'm talking about shares because today you have to create a demat account. Every transaction is broken up into 3 expenses, etc., etc.
But see, the idea is do not leave your assets behind which can be disputed. That is the idea of a will. A will should be so clean, so decent, so simple that it can be interpreted very easily.
I would like to ask you one question anyway, on a will. In case you want to leave your estate to your wife and children equally, do you need to write a will at all? Is it better to write a will or die intestate?
Under what act?
Under Hindu succession.
Please write it.
Better to write it even then.
Please write it. Please write it. And be very specific. This, and that to the other. Be very specific, please.
Is it necessary to state that what you're bequeathing is self-acquired and not inherited?
Preferably, yes. Not only that, but also say that I have no debts. So that somebody doesn't come up and say, Mr. So-and-so owed me so much money. Preferably also say no debts. You could also be that you could bequeath something to somebody, say 10 lakhs of rupees to somebody. Say your son, who has taken a loan of 5 lakhs from you. What then? How do you account for that? You account for it, saying that he's taken a loan of 5 lakhs from me. If he doesn't pay it back into my estate before I die, from his share, please take away that much.
When you refer to the need to list assets, to be listing assets. Now you get a monthly statement from stockholding corporation, for instance. Can you mention that would be a listing of...
You will spend the rest of your life making wills.
No. Yeah, attach a copy.
Just say that. See, make it simple, please. That's what is called the KISS rule.
So
keep it simple, stupid, that sort of thing. Just
the
make
details are not necessary. You can say your
that
shares and
shares in Hindustan Lever go to so-and-so, in Tata's go to so-and-so, this goes to so-and-so, that goes to so-and-so. Please make it that way, because otherwise you are going to have problems. Especially if your children can't see eye to eye. And when the assets are very big, nobody sees eye to eye.
जैसा शेयर्स में सेकंड नाम होने में सेफ रहता है, सेकंड को चला जाता है, सोसाइटीज एक्ट रूल्स में ये अलग क्यों है?
Second name, Ashok, I understand. Second name, 5 shares. 5 shares. We've had this.
नहीं होता है, बोलते दूसरा जो तुम्हारा तीसरा जो जिसका राइट बनता है उसका
No, I don't get it.
अभी मेरा जो फ्लैट है 3 नाम से है.
You want to add a 4th name?
No, I don't want to add 4th name. तो मैं उसको पूछा मेरा डिमाइस के बाद मेरा वाइफ के नाम हो जाएगा, बोलता नहीं तुम्हारा जो एक और कोई सन है या और कोई हेयर है उसका लेटर लाना.
Put it in your will that whatever this flat must go only to these people.
इसमें विल नहीं लगता ना, शेयर्स में आप बोल रहे ना, उसमें विल का जरूरत नहीं हो जाएगा.
I didn't say that it doesn't go into share. You say that I own this much property. You own 1/3, right, in that flat. You can gift it to anybody you want, leave it to anybody you want.
लॉ में अलग-अलग डेफिनेशन है, शेयर में अलग है.
Yes, that is true. That is, see, the cooperative movement, the idea of a cooperative movement is totally different. When you say I am an owner of the flat, you are not. It's the society that owns your flat. You are only holding those 5 shares which allows you to occupy it. That concept. When Mr. Tata gets up and says, your company, Tata Steel, it is not your company. You can't take even one rock from there and sell it. It's just a matter of saying your company. You are holding a certain share. So here also the concept of cooperative society is totally different, because you got to go to the concept of cooperatives themselves.
So you pass on the shares?
You pass on the shares. And now if instead of 5, if you have got 6 people, how do you pass on the shares? I think it restricts it to 5. See, what you are holding is shares in a cooperative society.
And that shares are the public.
That's a different thing. See, another thing is what is liquid and what is not liquid is also to be considered. You can sell your shares on the market easily. Can you do that to your house? There are so many problems involved. The other day I was walking by, one more problem came up on this matter of nomination as to why the nominee should not be considered. First of all, the concept of the cooperative society. The cooperative society has no right to transfer shares on the debt. Who are they to do it? It's for the court to do it. Everybody does it and everybody sits tight on it. Who has given them the right to do it? Can a secretary pass off immovable property on the piece of paper? So what? Who has given them the authority to do it? And there are court, in fact it's in my bag, it's old judgment. Who's given you the authority to pass on immovable property like that? A cooperative society's committee is again no more than a trustee.
What would happen then? What do you need to do to say my son, I say, will inherit my...
Leave it in your will. Say that I've got 5 shares. These 5 shares must go to my son because I'm leaving the property to him in my will. See, a lot of people...
But then does he have to go to the court to get it? No, not necessarily.
But in your probate it will be done. See, I personally look upon the nominee as a person who has got a right to spend money, not take it. He's no more than a trustee. He has got a right to spend money, look after the property until the matter is settled. You get it? A lot of people say nominee hai, mera ho gaya. I know a lot of societies transfer it also that way. Nominee hai, it's a matter to be challenged. Who has given them the right? How can a secretary sitting in a small office transfer property as and when he wants it? In the same way, can some clerk sitting in the ACC transfer your shares? There has to be a procedure, and this is immovable property.
Sir, then when you are putting this in the will, should it be mentioned as a flat number so and so or something, or it should be shared?
As specific, if you can put a photograph of the door, please put a photograph of the door. As specific as possible, you have to do it, but your share certificate will show all that.
So if you are mentioning it is only shares, 5 shares, then that takes care of the whole property, or you have to mention...
You say share number so and so to so and so, both inclusive, 1 to 5 both inclusive.
Okay.
You usually mention the share numbers, the share certificate number, and you say along with it the flat number so and so and the right to use the, So, and you define the shares and the flat, your actual premise, what you occupy as premises. And you bequeath premises consisting of shares and your right to use and occupy the flat number so and so, at measuring so and so. And all right, title, interest that goes with it. So, you may have a sinking fund, you may have an interest in the sinking fund. That too is covered.
There are 2 or 3 types of different, we say ownership. In a cooperative society, that word ownership is in inverted commas. There's MOFA, Maharashtra State Ownership Act. There's condominiums. There are different types of ownerships. Most common is this one, which is a cooperative society. The only advantage in a cooperative society is collection of money. That's a very big advantage. If one person fails, you can immediately somehow or the other recover funds from them. Otherwise it becomes difficult.
Tenanted properties, how it can be, can it be covered in will, or what are other forms of protection?
There is a Latin maxim. It goes like this: Nemo debet quod non habet. Nemo means no one. Can debit means give away. Quod means what? Non habet, which he does not have. You do not own that property, so you can't give it away. Do you own the tenancy? No. You are a tenant, but you don't own anything. Because of that, there is a legal fiction called the Rent Act, which allows you to transfer tenancy rights, that means occupation rights, from you to the next generation, whatever it is. It's rather wide. It says that any relative staying with the person at the time of his death. Now, I really don't know how far you can go as a relative is concerned. But when Divya and I discuss it, I think about 4 degrees of separation should be, because that's Hindu law. It should be that. I cannot ask somebody who is miles away to claim to be a relative. Unfortunately, a person who is in occupation of the flat, maybe a very distant relative, who is in occupation of the flat, squats there, and then you have to take legal process to evict him. Just last week there was a case, person died. Fellow said, this is my aunt. The Parsi Panchayat says, no, you want the flat, so we won't recognize you. So they took the body and consigned it. Now that fellow has gone to court saying that I am the only relative. You prove that there is another relative closer to her than I am. Why did you not give me the body? It's now become a case of body snatching. Do you get it? So, property problems, 75 to 80% of the cases filed in the High Court relate to property. Okay, tell me.
So, nomination, it is tenant property, two names are there. One dies. So, the legal heirs of the first tenant, can it be passed? Do you have any rights, or it passes to the second tenant?
Let us be specific. A man is living in the house. He has a sister. And he also has a son staying somewhere else. To whom should it go? The sister or the son? What does the law say? The relative staying with him at the time of his death.
My query was, if the tenancy is in joint name.
Yeah.
First tenant dies. Second tenant
only, full stop. Full stop. No landlord what is sold is going to add another name to it. If one person dies and 3 people claim tenancy, the landlord is the happiest man in the world. He doesn't give rights to anybody. He says go to court and decide it and come. I'm not going to add more than one name on the rent receipt. He will be the happiest man, and if you don't fight, the landlord will make sure you fight. Somehow or the other will make sure you fight, so that he does not have to take a decision.
Okay. Good evening, sir. If a Hindu woman, she doesn't have a son, and let's say all the property is in her name, in case of her death.
Not even adopted?
Not even adopted.
Goes to her father, doesn't it?
No.
No, she does. Her husband is alive.
No. My question is, who's the class 1 heir? in this case? In
The
case of
woman's
absence of
husband is dead.
In case of
She has no heirs.
two daughters, let's say.
Oh, she has 2 daughters.
Yeah.
And you go 2 daughters, simple as that. Yeah. See, typical Hindu woman, you only think of an heir as a son. The daughters are nobodies. Ma'am, we are living in the 21st century, let us think of something else.
Thank you so much.
I have a friend, when I ask him, how is your family? He says, okay. Are they in Bombay? No, he's in Dubai. I said, what about your daughters? They're not my family anymore.
In 2005, sweeping changes were made to the Hindu Succession Act. So as the law stands today, not only are daughters co-partners, they can also be kartas. They have equal rights, that's right, they have equal rights in all, not only where we distinguish between self-acquired property and what is HUF property. Women have equal rights as men even in the HUF property.
That was before I married her. Now everything is hers. 2 years after I married you, they changed the law. Damn it.
Sir, if the will is typed and it is of 6 page and the person is signed only on the last page.
Seal it. Somebody said that it should be initialed on every page and signed. See, when do you initial? You initial. Now take this page. I would initial over here so that nothing is added. If I initial over here, it means that there's a change, somebody can change it.
No, the person has already died. And it's my
Do you think initials cannot be forged? It's so easy.
No, I'm just asking, it has to be signed on every page or not?
Initial the last piece, that means at the end of the page, as I showed it to you over here in this, at this point, please initial so that you cannot add anything to it. That's the idea, because in computerized things you can do almost anything. You don't add to it.
The question is that
if it is
already dead, she's asking whether it needed to be signed.
It's okay even if it is not signed.
Not at all. If you want to take this step only at that point, otherwise there is nothing. But normally when you have a will of 5 or 6 pages, please seal it. Seal it, stitch it up, seal it. In fact, this morning we did it for our own building. Seal it and have your mother sign across the seal so that it is not opened. See, today with computers you can do anything. It becomes extremely easy to do anything that you want. Originally, typewriting was very difficult to add a page or remove it. So please stitch it, seal it, so that nobody can tamper with it. The ideal thing would be to emboss it, because to copy something on embossing is almost impossible. Shall I start with the presentation? Will is a legally valid document that allows you to choose whoever gets what he wants. Person of sound mind, not a minor. As I said, once you become 18, you start doing it. A person who dies without making a will, it is called intestate. Even if you make a will which is thrown out by the court, you become intestate. My great-grandfather. You can only bequeath what belongs, as I said, memo debit. You can only give what you have earned yourself. Next, please. Hindu Succession Act applies to so-and-so, so-and-so, so-and-so. Parsis have their own Succession Act. Let us hope that one day we have a common law. Muslim succession laws are not codified based on the religious text. Shias, Sunnis, everybody has a different thing. Yes, now if you go to an advocate and ask him to... See, when I say make a will, your own will, I still believe that you should take legal advice, please. I mean, you can write it. The idea over here is you know what you want, you can assist them. But please don't just write a will and say, 5,000 rupiah bacha diya. It could lead to a lot of problems. Especially when personal laws are concerned. Please go and talk to your advocate, say, I am so and so, I have this, that and the other, and then please go ahead. Armed forces. privilege wills. If a person is fighting, man or woman now, at war and gets shot, somebody says you got 15 minutes to live. You can say that, well, I want this to go to this. But how it can be enforced is anybody's guess. The fellow who hears him might say that I saved his life, so he says take everything. How are you going to dispute it? So before going to war, please make your will. How are you going to dispute it? It's almost, anyway, this is a provision that is being made for people in trouble at the last moment, but only if you are at war and not fighting with your wife. You have to be fighting with the enemy. Okay, next man. Testator is the person who makes it, testator, testatrix, executor, executrix, etc. Legatee is somebody who gets it. He's also a beneficiary. Codicil is an addition to the will. You make a will of 50 pages. Please don't. You make a will. You want a little bit of a change. Your executors die. You can make just one page saying that instead of that, according to my will, everything else stays the same. But I am giving it. These are the two new executors. Or if your daughter dies, you don't want to give anything to your son-in-law because otherwise it would have gone to the son-in-law. You change that. Nothing goes to my daughter, cancelled, no son-in-law, nothing. Everything goes to the other people. It's.
You need witnesses for that?
Yes. Executor is one who is appointed to execute. Administrator is the one by the court. That is a problem. Try to avoid it. Testamentary guardian usually appointed mainly for children. Next. Conditional and contingent wills. Another problem. Because it could very often clash with our constitution. You might make something that subject to this, that and the other. A simple thing. I have a daughter. My daughter gets my estate only if she marries a Parsi. Totally unconstitutional. Suppose she hates men and doesn't want to marry. What happens? Or does she collect it and live with her boyfriend? She's not married. She's still living with her boyfriend as a non-Parsi. Try and avoid these things. It will only create problems. Joint wills. Somebody wrote me a letter after this was circulated, joint wills. It's not bad. It's quite good. Normally between a husband and a wife, saying that if I die, if say husband dies, everything goes to the wife, and when she dies, everything goes to the children. It's quite a normal thing. Or it's almost like a husband and wife making separate wills. Husband saying that if I die, during the lifetime of my wife, she can enjoy the property, take the interest, etc., after which it will be distributed. She writes the same thing. It's the idea is to take care of the spouse or the other person. Nothing wrong with it, but please word it very well. Mutual wills is almost the same thing. Lot of people coming together and doing it, but again, as I said, I would like to avoid it. It only creates problems. Yeah, you're please consult a lawyer. See, the problem with wills is you never know what is going to happen. It's almost, my idea of talking to you here is that when you go home, all of you will say, damn it, I'm not going to make a will, it's too much of a problem. Because it is a problem. You have to be very careful of what you want to do. It's not that easy to write a will. It is difficult. We have to ask a million questions. If one person comes, we ask a million questions. In fact, they feel that we're sort of intruding into their private affairs. But we need to know. Otherwise, you can't make a good will. Okay, next, please. To ensure proper distribution, why make a will? You can repeatedly revise your wills. Yes, we've come to that. To ensure that your money, charity. Originally, when people were about to die, some Guruji or Padri or whoever it was would come and say, you lost a very bad life. You will go to hell. See, you got 10 crores of rupees. At least 9.5 crores you should give to the church. Naturally, when a person is dying, he doesn't want to hear all this. So the poor fellow will donate it. So they had a 6 months gap. Hopefully that in 6 months the fellow will recover and decide not to give the money. So, if after making this sort of a will for charitable purposes, if you died within 6 months, it was considered invalid. Yeah, it was. Yeah, see, whenever a law is made, please don't just think of the law. Try to think of why it was made and then act on it. And please don't try to think when you read it. Our interest is when we read it, we only want to read what is good for us and not what is not. But every law, and we have fantastic, not the recent ones, not in the last 10-12 years where Babus are writing laws after the other. But otherwise, the laws that we have inherited from the British are really fantastic. Really fantastic. Do you know that the British actually tried out their new laws in India before introducing them into England? Really, the IPC. It was for 18 years they tried it out here before they introduced it there. As it is, they don't have a written constitution. They had common law. So we have fantastic laws. I'm not joking. Every law has a meaning behind it, and that is how you should read law. Don't read the book. Ask the question, why has this been done? And I promise you, if you have any wrong done to you, you will find a relief in the statute books. There is nothing in the world where if you have been honestly hurt, it is not in our statute books. It is there. You have to find it. Our laws are fantastic. Unfortunately, a constitution is as good as the people who want to abide by it. For appointing executors or creating trust. Yes, trust. I have a son, druggist. I am 90 years old. I might pop off tomorrow. That fellow comes to me every day. Daddy, give me 1,000 rupees. Goes and takes drugs. After I die, he'll spend 1,00,000 rupees a day on drugs. He's my son. I want to look after him. What do I do? Create a trust. Say that they will give him this much money. Next question. Suppose he becomes okay. What do you do? Is he entitled to that money? Suppose he gives up drugs. He turns over a new leaf. Daddy is there. I should have listened to him. I am going to give everything up, lead a good life. And he really leads a good life. What do you do?
Build it into the trust deed.
Who decides whether he is okay or not? See, again, one more problem in a will.
Isn't that a problem with all trusts in India? Because trusts are recommended, especially people who have special children with special needs, maybe mental.
I agree.
The point is that a trustee there is even more difficult than finding an executor who's going to do the job.
Yes.
So how do you get around it?
See, you decide on a person whom you think is going to look after your children. That is about all that you can do. You trust the trustee. What more can you do? You're not going to come back from your grave and take it all back. It's just luck. You leave it to luck. You might even appoint 3 trustees. All of them might be crooked.
We've been trying to find examples of how trusts have worked in India, because all these trusteeship companies like ILFS and ICICI, they are recommending, so a lot of young people who are in their 30s and 40s, especially the kind who work in the financial sector and are earning really fat bonuses, I think most of them have been told, create trusts for your children. And
we keep saying that how do you sort of enforce and implement the trust, and we've been trying to get examples, but all we know is lots of trusts have been created because these people are all alive and well. Okay, so it's never been tested to see whether the trustee executes it the way they want it, do they look after their children. Would you know any examples?
My wife does. Excuse me, I'll just have a drink. My wife wants to say something.
I have come across a number of for minors, and usually the trustees have a clause that upon when they attain majority, they will have to approach the High Court and they can dissolve the trust. So these kind of trusts, they do seem to work, because ultimately one day the minor will become a major, he will be a wiser person, and any office of trust is criminal breach of trust under IPC has the same term of punishment as rape. It's 7 years. So the office of trust, if people know, they realize misusing that office, the consequences that they can be saddled with, I think it might, they work out.
One more question. If the child is a minor and in good health, he will grow to be 18 or whatever and will fight for his rights. But if the child has special needs, is mentally disabled or whatever, and they're not able to do it, and then the trustees gobble the money, can anybody else
Best friend. Anybody, even you or I can do it. Even if you see anybody is called a best friend, you can move the court. I'm telling you, our laws are fantastic. It's only that we don't know them or we don't implement them. You find the child on the road that is being kicked around, and you find that the guardian is not. Take care of the child, go to the court and say, I am the child's best friend because I saw the child being harassed. Then the court will listen. I'm telling you, they'll listen to you. They will listen to you. It's called best friend.
What about the cost then?
Normally, if you act as a best friend and you have to spend a bit of money, it will come out of the estate of the child. The court will give you the... See, I'm telling you, all the laws are perfect. Really, the laws are perfect. There's nothing wrong with our laws. Implementation. We are unfortunately being looked after by crooks. Full stop. The laws are perfect. You can't make them better. As I said recently, some Babu writes that if you break into, like that gentleman's paper on the net by stealing his password, 100 years jail. He just writes 100 years jail. For what? I mean, there should be some thought behind it. But otherwise the law... Do you know that if somebody comes and throws you out, like recently, like trustees, you said trustees, and anyway, it's a very recent thing, we've been doing it for the last 15 days. Pasi Panchayat. They threaten everybody, sign leave and license, otherwise we'll throw you out. Bag bistaro feki daiso. Can it be done? And if it is done, suppose somebody comes and just picks you up and throws you out of your house, what will you do? Within 48 hours, the court will put you back in possession. All you have to prove is that prior to that day, you were in possession for 2 months. If you can prove that you were in possession, the court will put you back. It is for the other person to prove that you don't have a title, he has a title. Laws exist. People don't know of them. People are scared. People think that things are so bad that we are not going to be able to get anything done. And most probably, and this is a personal case, I am involved in that case, most probably the person who throws you out goes to court and says that I want title. Frivolous litigation. Have you ever heard of anybody being hauled up for frivolous litigation? The law exists. Unnecessary prosecution. The law exists. You can't take people to court just because you feel like it. That's why our courts get clogged. So next one. will must document all your movable and your, please make a very nice list. Must be signed by 2 witnesses. You could have 3 also if you want to. Correctly identify. I brought that. I'll give you the pen drive. You can put it on. For the witness, please make it very clear. Signature of the witness. The name in capital letters, preferably by the witness himself or herself. Address, occupation, age, maybe even telephone number these days, so that the witness can be traced. And nobody really does it, but after a year or 2, get an affidavit from the witness that I have seen this signature. Suppose the witness lies, both of them lie. Then you have to prove the witness's signature. So after a couple of years, one more paper once in a while will you don't want your witnesses to die on the spot, do you? In fact, if you did it immediately, the courts might wonder what the hell you're up to. Law does not prescribe a format for wills, but please, I'll give it to you if you can. It can be done on plain paper. Holographic is better. No stamp duty, no payments, nothing. Remember, my secretary, why should I pay the lawyer so much? It's not done on stamp paper. Lawyer asks for some money for a will. She says, it's not done on stamp paper. Why should I pay you anything? There is no need for a stamp paper, just a plain paper. But please make sure that the paper stands the test of time. Please make sure. I mean, God willing, you'll live for another 50 years. We don't want it to crumble. A will can be revoked or updated any number of times. If you do it 50 times in 3 years, the court is going to wonder whether you are of your right mind or not. So please, just don't sit around changing them. A will can be updated through a codicil contain a residual. Yes, a residual clause is always necessary. Anything else that is left, please give it to so-and-so. So that if there is anything left, any residue, it is not disputed, it does not hold up your probate. Okay? I am making out my will. If there is anything you want me to leave to you other than the debts. Can you leave your debts to your legatee? But it can be taken from your estate. If your estate is 10 lakhs and you own 15 lakhs, your legatees get nothing, but that doesn't mean they have to pay the balance 5. So that is why I mentioned, please write, I don't owe anybody anything. Make it very clear. If an executor is appointed, he, she must be clearly identified to avoid ambiguity. As I said just now, whatever it is, please be very, very specific. Executor must be a person you trust and ideally with the knowledge of the law. Basically, 95% honesty. 95% honesty. What is a probate? Probate is nothing more than the court saying that this will is valid. It's a piece of paper, a document which is correct in all respects. They do change in different states, but not by much. Only thing is, as I said, if you are making a will in a language other than English or Hindi or Marathi, a common language, please make a translation in English and get it signed. Even Marathi, Hindi, even in Bombay, see that every testamentary matter goes to the High Court. Now, every High Court judge is not perfect in Hindi and Marathi because High Court judges come from other High Courts. The common language for them is English. So, as far as possible, try and keep it in English because testamentary matters go to the High Court. They don't go to the lower courts. So, try and keep that in English. If you can't, then please keep a translation. Companies prefer to recognize wills that are registered. I don't know why. the law doesn't say it, so I don't see why they should do it. Just a matter of delay and being safe. Transmission of immovable property usually requires a probate. Why? Because there's a registration involved. Gifts while alive are considered to be inefficient today. Okay, I've written that point too. I have a beautiful carved cupboard which I'm allowing my son to use for 3 years, 5 years. No questions asked, you use it. Can I put that in my will? You gifted it to him. What you gifted, you can't take back.
You have allowed him to use, not to...
You've given it to him. That's his. You take it. You do what you want with it. It's his. For some length of time. You don't put even one shirt of yours in it. Our Parsis do that. One sari in each cupboard to make sure that the sari, that cupboard is mine. Mori sari andar mukeli hai. They know the law. Parsi ho sabhe. Mukish ke sari ho mukish ke kehte hain. So that you can't. You've given it away. That's the end of it. A gift is a gift. You can't take it back. Full stop. Insurance is that is Dalal will tell you. Insurance, what to do with it, how it should be distributed. Keep that clear. You can mention it in your will that I've got so many insurance policies given to so and so, so and so, so and so. These are the persons who will benefit from it. Single breadwinner of the family, it makes. Obviously anybody, it makes sense today and it makes sense for insurance for anybody. If a man buys a policy under the Married Women's Property Act, the proceeds cannot be... There are certain laws that protect women. And it's good. Another thing is, we talk of women in the cities. Women in the villages, they hardly know the law. They can be harassed and manipulated. So these sort of laws protect them. Let's not just think of Bombay. Let's think of other places also. A trust can be registered under the Indian Trust Act. You can transfer funds and property to the trust, which has become a holding vehicle. We've discussed that. Trustee manages the trust as per the trust deed. The most important thing in your trust must be the objects. Nothing is more important than the objects. You can't go below the objects, you can't go beyond the objects. Objects is it. That is the idea of the trust deed. The object must be very, very specific. You can't add to it, you can't subtract from it. You can access and control assets while you are alive and decide on the distribution. A lot of people form trusts and become the trustees themselves. Until they are dead, they themselves become the trustees so that they can control it. A trust protects you from assets from your probate, yes, because see, once you put it in a trust, it's out of your hands. It's not yours anymore. You might control it, but it is not yours. Tell me, since we are on trusts, to whom does the trust really belong? The public trust, to whom does it really belong? The trustees? Then who? Somebody must own it. Right, who said that? Right, absolutely right. The final authority for owning a trust is the charity commissioner. Not the trustees. Especially we Parsis think trustees who can do anything that they want. No, it's the charity commissioner. He is the final authority. The trustees are no more than managers. They have to make sure that the objects of the trust are met. Now suppose you have 2 sons, both of them druggists. You create 2 separate trusts. After some time one dies. What happens to the money? Common objective. The common objective is your second son.
It goes to him or to the government?
Yes, common objective. The government can't take it away. The common objective, the closest common objective. If I have a trust for feeding women over 60 in Dadar, and there are no women over 60 in Dadar, but there are women over 60 in Parel, the charity commission will put the money there. The object of the trust is still met. Maybe not in Dadar, but in Parel.
But is this again a case where the law may be good, but its implementation could be really outrageous? Because even for NGOs, we hear of how much of harassment you can face from the charity commissioner. So if it is a trust belonging to somebody who is really wealthy and the people who are the beneficiaries are weak, like you said, drug addicts, then can't they be harassed by the charity commissioner rather than helped?
Ms. Dalal, as I said, no matter how good the law is, if the people are bad, it becomes extremely difficult.
Does, again, coming back to the question I asked again, especially because so many people are being advised to make trusts, does it make sense according to you? Is it?
Nobody makes more trusts than Parsis do.
Has it been working well?
There are 35,000 Parsis and 50,000 trusts.
But is it working well? Especially for, no, I'm talking about inheritance. I'm not talking about Parsis give a lot in charity and those trusts work well. I'm talking about what happens for individual families.
I would agree that NGOs are being harassed, but we also can look at the other side of the coin.
No, I'm asking about purely succession. If you make a trust as a vehicle of succession in an individual family, has it been working well?
In a family?
Yeah, I mean, you want to leave for a child, who is disabled and can't take care of himself. So you put your property in a trust.
It depends on the trustee. As I said, it depends on the trustee, the person who is doing it. If the trustee is not doing it properly, if you feel that he is not doing it as the best friend, you can approach the charity commissioner. I'm talking about private trust. Sorry, private trust. My mistake.
Well, I had a trust.
Go to the court.
No, I had a trust created for me by my grandfather, who did it for all his grandchildren, but admittedly 60 years ago. And it worked very well because the trust deed said that as soon as we turn 18, it reverts to us in our individual capacity, and it worked extremely well for all the grandchildren, no problems at all. But this was in the 50s and 60s, not today. I don't know whether the laws have changed or what.
As far as private trusts go, it's been my experience that trusts created for minors have really been quite successful, but you cannot circumvent the laws. People think that if I have a trust, then I need not enter into any legal hassles. When you want to dissolve the trust, and ultimately you cannot keep property fallow. You cannot keep anything
unused.
The only way, even supposing I don't want to, there's a property, immovable property, for example, you cannot say this piece of land can never be sold ever. The only way you can do that is putting that piece of land in a public trust, and there too you have to seek the charity commissioner's permission. So ultimately, even if you keep a private trust, you cannot circumvent the court. Tomorrow, if you have to dissolve it, you will have to approach the High Court to dissolve it if the property is in Bombay.
What I thought was private trust for maybe a child, and the trustee doesn't really do his job. What do you do?
Or takes away the money.
If you come to know about it, you can definitely move the court. You can, because it's a fraud. I mean, it's a crime.
And there is no limitation. The Limitation Act has a exception in case of all trust matters. So obviously your limitation, once you come to know that you have been defrauded, from the date of knowledge, the limitation may kick in. But as generally, it's supposing you come to know that you have been the trustees pilfered your property and gave it away to somebody else 15 years after the event took place. Even then you can pursue that property in whosoever's hands it landed to. Your rights are not dead because of a Limitation Act.
I know of cases where money has been left with a trustee to look after the child's education, welfare, food, clothes, etc., etc. The poor child is kept like a beggar. everything is taken away. But in that case, you can move the courts. I see no reason why you cannot. You can go to the charity commission, that's true, because it's a private trust.
Life insurance policy nomination is done when the policy is taken.
When the
policy is bought,
yes.
Taken. Now, through will, can I supersede? I mean, if I want to change it.
No, you have to go to the insurance company and get it changed. There are forms for that. You can get it done through the insurance company.
Sir, if 5 lakhs rupees shares are there and you have to provide a bill for that, how much will be cost?
Yeah, see, the maximum is 3 lakhs. No, 75,000 rupees. Sorry, 75,000 rupees. Maximum is 75,000 rupees. You have to pay that. If it is less, there's a chart. It comes to, I think, about 4% or so as far as the 4 or 5% as far as the estate is concerned. They have got slabs. I mean, it doesn't really mean exactly 4%. They've got slabs. It's easily available. I think it's on the net now. So you have to upper limit. Not 3 lakhs. My mistake.
Before we wind up, we're way past the time. It's been very, very interesting. Some closing remarks and some questions. You talked about a draft will. So some people want to know whether you'll give it to us and we can email it to anybody who asks for it.
You can do that.
We can do that.
It's a very simple draft. And you could start with that before you go to your lawyer or whatever.
We'll take it from you afterwards. So whoever wants it, write to us and we will email it to you.
Anything. I'm not here to drum up business. Anything that you want must come through Moneylife. How many of you are members of Moneylife? A few of you aren't. I'd suggest you become members of Moneylife.
Because it is free.
Before Ms. Dalal makes such a big impact on the country that she might start charging it. So right now when it's free, let's get it done. Anything that is free we should grab right now. Who knows what will happen tomorrow. And seriously suggest that each of you try to get 4 or 5 board members. I mean, we come here, nice air-conditioned place in a nice place to sit. I'm sure there's tea and biscuits today too. I mean, the minimum that we can do is to make more members. And we have been discussing this matter of having some sort of legal, not aid, you pay for it, but a nominal amount, once a week or something, which you could, if you have your own personal problems, like this gentleman has, you'll be charged for it. If he has it, in that case, we are seriously thinking of having something like that. I wish Samir was here, Javeri. I mean, he's really a live wire. He's doing hell of a lot. And people just come here to have a cup of tea, talk and go away. I genuinely think we should, each of us, if we make 5 members, we will have 1.25 lakhs within no time.
Thank you very much, Mr. Malcolm. You're the first speaker to say this. We really, really appreciate it from Moneylife Foundation.
You're going to pay me for this, aren't you?
Not at all. It's all free.
I suggest everyone should subscribe to magazine.
That's paid.
I love the magazine. Unfortunately, I don't have the money. It's a beautifully done magazine which says put this money here, put there, do this, do that. I am waiting for...
Okay, so wonderful session. Very,
God
very
bless
interesting.
you. I'm so
Thank you so much for spending time.
I'm extremely happy. I mean, if go home and write your will.